Congressman Smith, who's Marshall Miller?
Marshall Miller was a prosecutor I've worked with.
And well, let me go back to last hour. You said the Democrats, I believe, asked you whether you lobbied for the position. And you said you didn't. But then you followed up and you said you made a call to the Justice Department, someone you knew there. And I think I got the quote right. You said, if there was the right position, I would be interested. What was the right position you were talking about?
If I could take you back, Marshall Miller is the person I was talking about.
So that was my next question.
Yeah, I learned that he was returning to the Department of Justice. I was still overseas at this point in my State Department position. I reached out to congratulate him about coming back to the department.
And what position did he have at the department?
He was a senior position in the Deputy Attorney General's office. I'm not sure I'm going to get the exact title right, but it was a senior position in the Deputy Attorney General's
My
office.
understanding, he was Principal Deputy Attorney General, number 3 position.
That could well be.
Okay, so you called him and you told him what?
Well, I initially called him to congratulate him on coming back to the department.
Okay.
And at some point, I told him that if the right position came up, I would be interested in returning to the department.
And what was the right position?
I wasn't specific about it. I just told him if the right thing came up to sort of keep me in mind.
What did you have in mind? Do you want to go back to running the public integrity section?
So
Do you want to be a line lawyer? What do you want to do?
what I recall is right around then, there was a domestic terrorism unit being set up. And I don't know if I shared that with Marshall, but that idea that was being set up, I was interested in things like that, but I didn't have a specific.
When did the call take place?
Well, it wasn't, I'm not going to remember specific conversations. I know shortly after he returned, I reached out to congratulate him on returning to the department. At some point, I don't know if it was then or in a call after that, I said if the right position came up, I would be
And so
interested.
you're saying today, you were no way referencing what many assume might happen, which would be there be a special counsel looking into President Trump. That wasn't on your mind. You weren't anticipating that.
When I told him I'd be interested, no.
Okay. Okay. Let's go back to where we left off in our first hour with the toll records. So you seem to indicate that you felt the burden was on the carrier to comply, and that you felt that was consistent with the statute that applies to the United States Senate. Did you feel like you had a burden at all to tell to let the carriers know that we in fact are looking for toll records for numerous United States senators?
I'm sorry, sir. Which statute are you talking about?
The statute applies to the Senate, where you reference that you think the burden is placed on the carriers to deal with this issue with senators, done by the House, but the senators. In our first hour, you said the burden's on them to, if they're going to let the Senate know that their toll records are going to the government, the burden is on them. And I'm just asking, do you feel like there was any burden on the prosecutor, on you, to tell, to make that public?
To make that public?
Not to make it public, to let the carriers know, we are in fact, make it public to the carriers, we are in fact asking for toll records for United States senators.
Sir, I don't recall discussing that particular statute. I may have. What I meant to communicate was that reading that statute as it existed at the time, reading it now, it's clear to me that the process that was envisioned.
So you didn't know about the statute back when you requested the tolls?
I do not recall discussing this statute. I can't
Okay.
recall if I knew about it then or not.
Okay, there's definitely a burden based on what the Justice Department is now going to do and move forward. There's definitely a burden now, but you didn't think there was any type of burden for you to let the carriers know these numbers we are giving you are numbers for, excuse me, for United States senators.
As you referenced, the statute has now been changed. And before that change, My understanding is that the statute directed carriers to do this analysis, and in fact envisioned that carriers might get.
So there's no
NDR
burden on you,
obligations.
no burden on the prosecutor. That's what I'm getting at.
My reading of that statute as it was drafted at that time is there was not.
Okay, and you ran the public integrity section back in your days at Justice Department, is that right?
Correct.
Did you ever get requests for toll records for this internal analysis that you think was, as Steve said pretty cursorily, did you ever get requests for members of Congress or United States senators, their toll records?
It was some time ago. I'm sure we may have. As I sit here now, I can't remember a specific instance, but I'm not saying.
How long were you head of the public integrity section?
I was the head from May of 2010 until it was either January or February of I believe 2015.
Okay, 5 years, and in that time frame, you don't know if you got, you can't recall, you may have, I think is, I'm gonna be fair to you, that you don't recall any request for the toll records of members of Congress or United States senators.
Well, I'm saying we may well have, and
Okay.
that may well have happened. I just, as I sit here right now, don't recall a specific instance of that. I'm not denying that that happened.
Okay.
Once the department gets the records, what does it do with it? I know the FBI has something they call the Cellular Analysis Survey Team, CAST. But do you know what happens with the records once they get them?
The analysis, like how they do the analysis.
Like, what do you do with the records?
That would not be in my area of expertise, how the analysis is actually conducted.
And how does that get rolled back into the team?
What do you mean?
The team's work, the prosecutor's work. So you subpoenaed Speaker McCarthy's toll records after he became Speaker, and you sought records from November 2020 through January 8th, 2021. Like, what were you looking for with his records? Like, what did you do with the information you obtained?
Okay, so what the relevance of those records, there'd be several examples, but his contacts with either co-conspirators, the president, or conduits of information to the president was relevant to our investigation. And an example I could give you is on January 6th, we had information from Mark Meadows, who was present for a call where Congressman McCarthy was asking for help. He was asking the president to come to his aid while the Capitol was being seized. Getting the exact toll records for when that happened was relevant for our investigation, both to question other witnesses about, so we had an accurate timeline, and also to corroborate that the call happened at approximately the time witnesses said it happened.
But it's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy and we followed all legal requirements in getting those records.
I mean, well, you know, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time, and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case.
Right, but you could have asked Elliot Burke for that information, the speaker's lawyer. You could have asked Elliot Burke to say, can you get us the speaker's, phone records for this time? And he probably would have said, of course. Avoiding a toll record subpoena.
And your question?
Why didn't you do that?
We got these records in a manner that was consistent with the law and consistent with department policy. There was nothing improper about how we got these records.
Same with Representative Perry's phone. I mean, you could have asked Representative Perry's lawyer. I mean, there's no evidence that Representative Perry or Speaker McCarthy was interested in obstructing your work, was there?
I don't have any evidence that Speaker McCarthy was, I don't recall any evidence, I should say, that Speaker McCarthy was interested in obstructing our work.
Okay. So with Representative Perry, you could have contacted his lawyer and you could have said, this is what we're looking for. Can you help us achieve this without seizing his phone?
Well, with Congressman Perry, I should point out that the seizure of his phone happened several months before I was ever special counsel. I wasn't
Fair
involved in that process.
Yeah, okay. But in hindsight, would you have counseled taking a different avenue to acquiring a member's phone?
I'm not going to speculate on investigative steps that occurred before I became special counsel.
Okay. When obtaining the toll records of members of Congress or anyone, what is the standard? Must there be some evidence that relates to a criminal prosecution or criminal investigation?
So there has to be a reasonable basis to believe that there will be materially relevant evidence.
Okay. Now, with the chairman of the Judiciary Committee, the subpoena, with Speaker McCarthy, the subpoena, the timeframe was November 2020 through January 8th, 2021. With the now chairman of the Judiciary Committee, the timeframe went back to January 2020. So it was for a full year where, between January 2020 and December of 2020, nobody, had any telephone calls about these matters. I'm just curious why you went back to January 2020, the office did.
Sorry, I just want to clarify. When you say you went back, can we just get the date of when the
It was
subpoenas
May
were
1st,
issued?
2022, and it was before you were appointed. When I say you, I apologize. I mean the office, the effort. I mean, this was before you became special counsel. The DC matters were headed up by Thomas Wyndham, as I understand it,
I believe that's right.
and the Florida matters were headed up by Jay Bratt.
That's
Okay.
correct.
And so the question is, why would DOJ, why would the team seek records from January 2020, through November of that year, before any of these issues, before anyone knew about any of these issues?
Yeah, I played no role in that subpoena. I was still in Europe at the time. And because I wasn't present or involved, I'm not going to speculate on the basis for the range of time that the prosecutors in that case saw it.
Okay. After you became the special counsel, that information obtained from the subpoena, was available to the special counsel team. What did the team do with it after you became, after you were sworn in?
You mean, when you say that information, you're talking about the
The
total?
toll record subpoena for the chairman of the committee.
Well, I can tell you that, for example, there was contact on, for example, January 6th, that again, another example for you is Mark Meadows. When we interviewed him, he referenced the fact that afternoon, Chairman Jordan had been in contact with the White House, and like Congressman McCarthy's contact with the White House, it was relevant because, and again, Meadows stated this, that these were supporters, these were credible people that the president relied on. And what I recall was Meadows stating that I've never seen Jim Jordan scared of anything. And the fact that we were in this different situation now where people were scared really made it clear that what was going on at the Capitol could not be mistaken for anything than what it was. And it goes back to that sort of information from someone who is a credible source to the president, proving that that actually happened and that there's actually a record of that call and exactly when it happened and what actions happened after that or didn't happen after that, extremely probative to our case.
Right, but DOJ took Mr. Jordan's phone records from January 2020 through November, through January of the subsequent. I mean, what on earth could the Justice Department want with his phone records before time's relevant?
Sure, and the breadth of that subpoena was before I was special counsel, and I wasn't involved in the deliberations about seeking that subpoena or the breadth of it, and so I can't speak to that.
Okay. Can you see from our point of view that there's a perception that there's some overreach going on there?
I understand your question. I don't have any, and I do understand it, I don't have any reason to believe that that subpoena was secured for any improper purpose or that it was secured in contravention of department regulations or the law.
Okay. And in terms of